Hey guys, Seth Fuller, your favorite attorney here. Today I want to talk about a kind of interesting case that's going on in Florida right now. Now, generally, this is your standard man falls in love with woman, woman falls in love with man, man murders woman in her front yard by nearly cutting her head off. But there are two things that might be interesting to justice nerds like myself. If that's not you, maybe not the video for you. But there's a Fifth Amendment right and a due process right that both are implicated here. And there's an interesting rule that is in Florida and not many other states that is being used, so I thought I'd go over those things. So the case I'm talking about is the trial of Mathew Terry, State of Florida versus Mathew Terry. Now, Mathew Terry is a man who is accused of murdering his girlfriend of the time as she was trying to leave the residence. That's calling the fleeing girlfriend murder. In any event, there was a police call. They heard screaming and someone fall, and the police arrive and find this young lady, Kay Baker, a 43-year-old teacher, dead on the lawn, just neck cut to pieces, and They find a blood trail leading off into the woods. They call the bloodhounds, and the bloodhounds find her boyfriend, Mathew Terry, sitting in the woods, covered in blood. He had 2 marks to his neck. I believe the state is saying that those are self-inflicted, but in any event, he was arrested, taken to the hospital, and then immediately taken to jail. Now he's on trial for her murder, and this case reached national news because the first prosecutor wasn't going to seek the death penalty, and then a recently elected prosecutor changed her mind and said she is, so this is a death penalty case. But what's interesting to me about this, because again, the guy's caught, blood on his face, bad self-defense story. It seems like it's headed towards a guilty verdict. The only defense that I see is they're trying to use those neck wounds to say maybe self-defense, but waiting for that from the defense, because just as it seems right now, I'm not going to buy it. Now, again, like my last video, I haven't watched, or like some of the previous videos, I don't necessarily watch every single moment of a case that seems like it's cut and dried. It's got to be something interesting, and I was just kind of scrolling through some of the most interesting part of the case. That's the lawyers talking to me. Again, I'm a justice nerd, okay? In any event, I came across this argument that the state and the defense were in front of the judge, and I thought, man, that is interesting stuff. What I speak about is essentially one important piece of evidence and one not so important piece of evidence. So let me talk about the not so important piece of evidence first. So basically, when Mr. Terry is arrested, he goes to the hospital. He's sitting in the hospital bed, and the doctor asks him in front of a detective what happened. And Mr. Terry stayed silent. Now, you have a Fifth Amendment right, a constitutional right to remain silent, and that can't be held against you in any way, shape, or form. And that's one of the harder things as a defense attorney I have. I don't believe we actually do that. I've heard so many times, I've even given up on it, because I've heard so many times jurors after the fact say, well, I wanted to hear from him. Now, I don't hear that much because I get not guilties, way more than I get guilties. But when I do get a not guilty, when I do get a guilty, almost every time, and I think maybe even enough to say every single time, even though I prepped them, even though I questioned them, even though they swore not to, a juror will be like, well, I really wanted to hear from the defendant. So I've given up on that, but you do have that Sixth Amendment right, and they're supposed to set that aside. So here we have a very interesting argument that the state is making to let in not a statement, but lack of a statement. So while Mr. Terry is in the hospital, the doctor asks him what happened, and he remains silent. Now, mind you, there's a police officer sitting right there next to him. And the state wants to question the police officer about Mr. Terry remaining silent. Now, the only reason you would possibly want to tell the jury that he remained silent is that they're going to take that silence as some sort of guilt. And that's pretty much against the Constitution. The whole point of the Fifth Amendment is you have a right not to incriminate yourself, and that's an ultimate right. But basically the state is saying, well, it wasn't the police, and the Constitution is to protect you against the government. And so you don't have any Fifth or Sixth Amendment violations if the police aren't the ones questioning you, which makes no sense because, so the first step you think is, well, they would just hire someone who's not a police officer to question them, and then they would just listen and they would be able to say the answers without reading people's rights. But again, so what the state was saying is, well, as long as the doctor was under no instructions from the police and the police weren't doing anything wrong, if he had confessed to the doctor without being read his rights, that would be admissible. And they're right. Even though you have a right to remain silent, if you don't exercise that, and it wasn't the police who was questioning you, but the police overhears, even accidentally, unless that conversation was privileged, like let's say he's telling his attorney, maybe even a doctor with no policemen around, and they overhear. I'm not sure about that one, but definitely your attorney, your spouse probably. And so if they're using a third party to say that, unless you had a reason to believe that the communication you're making was privileged under the law, then if someone overhears you telling your brother that you killed the murderer, there's no assumption of privilege, and therefore if a police officer is walking by the hospital room while you're telling your brother I did it, then that is admissible, and there's no doubt about that. But now what this attorney was saying, what this prosecutor was saying was, well, we should apply that rule to the fact that he didn't say anything. And the fact that he didn't say anything and it wasn't the police is incriminating, and I should be able to get that in front of the jury because the police didn't do anything. The doctor asked of their own free will to the question, and he's remained silent, and I should be able to tell the jury that he remained silent. But again, the only reason he wants to even do that is because he thinks his silence is incriminating. And so there's this weird thing that, like, wait, this is what the state thinks. I'm just going to tell you, most DAs I know think like this, that if you don't say anything when questioned, that's incriminating. If you say something, that's a lie, and they're going to use it and say it's incriminating to incriminate you, to cross-examine you. If you confess, of course, that's the most incriminating thing. But basically, the state goes, there's no good answer here. When the doctor asks you what happened, it's either you're incriminating yourself by remaining silent, you're lying by telling a story that mitigates you or paints you in an innocent light, or you're confessing, which should be admitted because the cop was right there and you had no right. You didn't think there was any privilege involved. So all of that comes to this state making a ridiculous argument, but the judge denied it, and so they're not going to let in the fact that he remained silent. Again, that's not a huge piece of evidence. I think even a jury would be like, well, yeah, he has a right to remain silent. But luckily, the judge was like, this is a ridiculous argument. There was a cop there. The doctor asked what happened, and he remained silent. That's him. His only other alternative was to say what happened and incriminate himself. So if he didn't incriminate himself, that's his right. So it was just one of those justice nerds, like, what is the state doing? But this is the kind of thing. If you think the state's on your side, let's say this guy was innocent. Turns out he had fought off an attacker, but he's scared of what might happen for whatever reason. And someone else had killed his wife. Let's say a bad guy who owed him money. I don't know. I'm just making up a statement where an innocent person might remain silent, but the state is going to use that silence against you, even though the Constitution protects you from that. Just think about that. That guy is arguing that your constitutional protection of the Fifth Amendment right to remain silent doesn't apply when you're talking to doctors in front of cops. The second one is much more important, but much less contested in this case, or easier decision for the judge than the previous one. So the state wants to get Matthew Terry's ex-girlfriend up there to testify that she was stabbed by him too. You see, he was, I believe, convicted of stabbing her several times, apparently, allegedly, and they want to enter that in. Now, why is this interesting? Well, because in every state, everywhere, the general rule, and it still is even in Florida, is that you can't use prior bad acts against you in the guilt and innocence. You can only use against you once you've been found guilty. So if you are on trial for assaulting your brother, they can't then bring in, well, but look, this guy stole from Walmart last year. That's a prior bad act. It only prejudices you, and it is not helpful. However, Florida has something called the Williams Rule. And the Williams Rule is essentially that they can use prior bad acts against you if they match up, if they're unique. So hold on, I'm gonna get more technical with you. I know all y'all were just waiting in the comments to be like, oh, this guy, you don't have it right. All these lawyers listening are like, oh, this guy's about to talk about Florida law. He's not even a Florida lawyer. So this has been codified, meaning made into code, which is a statute. So this is in Florida Evidence Code 90.610, which says that similar fact evidence of other crimes, wrongs, or acts is admissible when relevant to prove a material fact and issue, including but not limited to proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, but is inadmissible when the evidence relevant solely to prove bad character or propensity. So a lot of states do have laws that are very similar, but California has what's called the Williams Rule, and says that what that says is that if the state jumps through the right case, that you can admit prior crimes that are similar. So basically a modus operandi, or just that you've done it before, so you've likely did it again. And they have a specific rule that says that. It's called the Williams Rule because someone named Williams lost because of it, and the court said that was okay. So the Williams Rule requires essentially that it be similar enough that it's unique. There be something unique about the previous crime you did that ties you into it. And so that goes back to what we're talking about, that shows like a modus operandi, that this is how you generally operate. And in this case, he's previously violently stabbed another young lady, and they're going to bring her in to testify. In fact, they're bringing a cop in to testify. It looks like the judge is only going to allow the victim to testify, and so this is generally a no-no, but because of the similarity between the crimes, stabbings of girlfriends, the judge is letting it in. Now, of course, the defense argued that that isn't enough. Just because it's his girlfriend and she was stabbed doesn't mean they're different crimes. One is murder, the other is just aggravated assault with a deadly weapon. Stabbing itself is not like a unique thing. Generally, they were saying you needed something more unique. The judge didn't buy it. Now, where this applies to Texas is we have very similar law in specifically in sexual assault cases, and Florida has the exact one too in addition to this. But essentially in Texas, they can admit evidence that you've recently or have before molested another child in child molestation cases. And why is this important in general? Well, the general rule, and me as a justice nerd, so why is this important to the law and to legal defense? Well, essentially, this is an important notion that you shouldn't be convicted for previous crimes on new crimes. Basically, anytime I commit a crime, that means that anytime I'm accused of a crime, even though I'm innocent of, I'm going to essentially be found guilty because they can just bring in all the other stuff I've done. Even if I completely turn my life around, which has happened before, by the way. People have turned their lives around and then been convicted of other crimes simply because of their reputation, and then it turns out, hey, it was an innocent person. In any event, this is essentially something everybody knows, and it's highly prejudicial. So but we had a specific problem with child molestation cases, in which in most of those cases, the child doesn't, it's just two victims. Child molesters don't molest people in public, and they go through great lengths of keeping it private, and that's generally when they feel they have the opportunity to. So you have this problem of child versus adult. Can you ever just convict someone off of a child's testimony that he did this? And if time elapses before the child tells, there's no DNA evidence, there's no physical evidence often. And so basically many states, if not most states, have enacted laws that says in these particular types of cases, child molestations, you can bring in something that another molestation, and you don't even have to be convicted of it in most places. Just if you've done three, if you've been accused three times, generally if they're totally different events, if you accuse three times of theft, they don't get to mention the other thefts, except in Florida under the Williams rule if there's a similarity, or except in other states that have that similar rule. But in child molestation cases in Texas and in other places like Florida, they say that no, this is, if you've been accused, then they can introduce that and the jury can decide whether or not. Now, I don't know if this is a good rule or not. It immediately, instinctually, I'm like, that's not a good rule. That's going to get innocent people convicted. But I also understand that a huge amount of child molestations occur in private by an adult who can be careful about when and what they do it and what evidence they leave. And so it just becomes very difficult. So I kind of do understand it, and I don't see really a much constitutional argument about it, except it just stings my heart that maybe innocent people are going to jail because enough people decided to accuse them of it. We have the witch hunts were literally, well, of course they were witches. Look at all these girls who are saying the same things, and we have that problem. Now, this isn't limited, as Florida has discovered and decided, this isn't limited to sexual offenses. Because let's say your husband, so there's a famous case back in the 1800s, and there's been subsequent cases very similar, where a guy was murdering his wives in the bathtub. And so they were ruled, the first two were ruled accidentally, and then the third one, somebody looked into it, and then they found out that there was two other ones, and this is back in the 1800s where records were hard to keep. But then eventually they're like, holy crap, this guy keeps doing the same thing. He got away with it twice. He still was compelled to do it a third time, and so he was convicted of all three eventually. And so that has happened in recent times where Scott Peterson, the second wife's body was exhumed, and it turned out she died in a similar way. If you watch that movie, The Staircase, that kind of talks about it, or definitely talks about it. But just generally, there's been a lot of these cases where it turns out that there are serial murders, whether men or women. There's also like Black Widow murders where a woman has murdered multiple husbands before she gets found out. And maybe you don't have enough evidence just in one case alone. But the fact that three other times the exact same thing has happened, your husband has died of food poisoning, or your wife has died in the bath, then, I mean, like, come on, we get the picture. And Florida has these laws that says those can be admitted. Texas has a law. It's a little more strict than the Williams rule, I believe, in that there has to be some modus operandi. In other words, if you have been accused of two murders of your wives, you can't bring that in unless there's that common thread, like being murdered in the bathtub. Two of them died falling down the stairs and breaking their neck. And so that's generally allowed everywhere. In my estimation, listening to this case, Williams in Florida kind of extends that out a little more to where, as long as there's like just one unique function, for sure you can let in even previous testimony of even unconvicted crimes. So I'm sure in Texas they've done something similar with our modus operandi law, but in ours is much more strict, in my opinion, but except for the sex with kids thing, and that one opens it up for the reasons we already discussed. Anyways, if you haven't watched it, it's continuing on Monday. If you're watching this anytime in Today's November 10th, so I believe on the 14th it starts again. They had to postpone it because they have a storm coming, and then Veterans Day, and so they're going to start back again on Monday with that girlfriend's testimony. So that should be very interesting. If you enjoyed this video, thought it was informative, go ahead and like and subscribe. I'm going to try to release more of these, and along with a lot of other more fun content and stuff we're working on. So I appreciate all your support, and have a good one.